Hello. Today, I'll provide an academic discussion of interim measures in antitrust investigations with an eye towards the digital economy. Starting with some background, historically, the use of interim measures has been scant, largely because of fear of false positives when an interim measure forbids conduct that will ultimately be found legal, hurting the defendant's business in the meantime. However, there has been a recent resurgence in the use of interim measures, this time driven by the corresponding fear of false negatives, which would allow anti-competitive conduct to continue unchecked during an investigation, generating a harm that cannot be compensated for. For example, some commentators criticize the 6 years it took the European Commission to conclude its investigation into Google Shopping, claiming that by that time, many rival comparison shopping sites had simply grown too weak to compete. Because of this new interest, I want to offer a simplified economic model of interim measures. And this framework can help guide the decision-making process for using interim measures or not. And while different jurisdictions may apply different criteria to determine when to impose an interim measure, the model can be adapted correspondingly. Let's jump into basic economic concepts that are going to be relevant for the discussion. So first, deciding whether to take an interim measure or not is a balancing act. An authority or court must balance the risk of over-enforcement, that is, imposing an interim measure when the investigation will find that no competitive conduct has occurred and hurting defendants unnecessarily, and on the other hand, under-enforcement, meaning that it's when they're not imposing an interim measure when the investigation will find that anti-competitive conduct has occurred, therefore missing out on the opportunity to limit harm. The risk of over-enforcement is called type 1 error, and that of under-enforcement is called type 2 error. The authority of courts needs to assess both the likelihood and the cost of a mistake and balance the two alternatives. This calculation essentially of the expected harm of the decision is crucial. The second and third concepts that are relevant here are those of urgency and irreparability. So if harms are not imminent or not irreparable, it makes sense to wait until the investigation is completed. You don't need to take an interim measure. And so interim measures are only appropriate in situations where the harms are irreparable, meaning that the harms cannot be compensated for at the end of the investigation. 3 conditions are necessary for reparability: that the harm is measurable, that the parties are able to compensate the other side, and that the legal system can ensure full compensation of all parties. And one thing to note here is that if an interim measure is taken by mistake, the harm will occur to defendants. So let's dig into the economic model of what I will call the optimal decision rule. So if you take into account these basic concepts that we just discussed, there's this following formula that can be helpful in deciding whether or not to use an interim measure. So you'd want to consider an interim measure if the expected irreparable harm to plaintiffs and consumers from incorrectly failing to impose interim measures outweighs the expected irreparable harm to defendants and consumers from incorrectly imposing the interim measure. We call this formulation the optimal decision rule, and it can be expressed mathematically as follows. So you have that, so H2 times P, which is the expected harm, the expected irreparable harm from over-enforcement, is greater than H1, 1 minus P, which is the expected irreparable harm from under-enforcement. If you look at the right of the slide here on the graphic, there's a representation of this optimal decision rule. The red line represents the expected irreparable harm from under-enforcement, because P is the likelihood that the defendant's conduct will be found illegal, and H2 is the irreparable harm to plaintiff and consumers from under-enforcement. And that line is increases with the probability that the conduct will be found illegal. And then in blue, you have the expected irreparable harm from under enforcement, and which that one goes down with the likelihood that the conduct is legal. So what you can see with this graphic here is that an interim measure should be taken when the red line is above the blue line. So when and that is when the likelihood of illegal conduct is above this P star, which is like the probability at which there's the two expected harms are the same. The rule will tip towards taking an interim measure if either the probability that the at issue conduct is illegal is high, because you get towards the right of the graph here. So it's more likely that the red line is above the blue line. And also if the irreparable harm from failing to impose an interim measure, which are represented by H2, is relatively higher than the irreparable harm from incorrectly imposing it, which is H1. A critical insight from the optimal decision rule is therefore the importance of asymmetry. The absolute size of the expected harm is irrelevant to the interim measure decision. What matters is their size relative to one another. That is how asymmetrical they are. So for example, if there's an increase in the time that it takes to complete an investigation, that would not tip the decision of whether or not to impose an interim measure, as long as it affects both types of harm proportionately. So that's for an example that we see here on the figure on the right, and that you see here, like if you increase the harm both H1 and H2 proportionally, the P star doesn't change, and so that whether or not to take an interim measure, that is not affected. So one important point here is that when you go from each decision individually to generally the question of an interim measure regime, there are benefits of an interim measure regime, because if used properly, that regime will reduce the expected irreparable harm. To see why, consider the two figures below. If you look at the left, that figure represents a world without interim measures, and the right illustrates the world that we just looked at with an interim measure regime. As the probability that the defendant's conduct is illegal exceeds P star, the total possible irreparable harm is the sum of the probable triangle, the harm the defendant and consumers would face if the interim measure were a mistake, and the hash triangle, the red hash triangle, which is the harm that would have been saved had the interim measure been taken. So in other words, the expected social benefits of an interim measure regime will be somewhere in the hash triangle. The purple triangle represents a change in who is harmed. So two factors are critical for making an interim measure regime work. First, you need to have reliable estimates of the relevant parameters. And two, regulators must have a consistent and rigorous methodology for making these calculations to assess the utility of interim measures. One of the insights here too is that the expected benefits of an interim measure regime grow when irreparable harm are greater. So for instance, if the time to take a decision is exogenously higher, or if it's an industry where more interim measure might be beneficial. Thinking about the use of interim measures in practice, it can be helpful to complexify somewhat the simplified model that I've just used so far. For instance, if there are reputational costs of making mistakes with interim measures, especially in cases of over-enforcement, this may lead the authority of using fewer interim measures compared to a world in which, compared to what would be optimal from the point of view of minimizing harms. Additionally, an authority or a court may want to have a minimal threshold in terms of the likelihood of an anti-competitive behavior, because there might be cases where an optimal rule would recommend using an interim measure, even if the probability of anti-competitive behavior is very low, if the harm the irreparable harm could be very high. And so that could be a potentially controversial mix. A last point is that the model I presented is using a linear framework, but other frameworks could be considered that have non-linearities. For instance, taking into account uncertainty around the likelihood of the behavior being found anti-competitive. And also, something you might want to consider is the following question. Why is it taking so long to take a decision? Is it an exogenous factor? Let's say, for instance, because the courts have a lot of cases that they need to look at first. Or is it endogenous? Because the conduct, for instance, is complex to evaluate, and that takes a long time. And so that's an important question, because in that second case, it may be counterproductive to try to rush a decision. Finally, I'd like to focus on the use of interim measures in the context of the digital economy. The digital economy often has characteristics that affect relevant parameters for interim measures. There are network effects, which drive larger changes over shorter periods of time compared to more traditional sectors. And there is also potential for more asymmetries. For instance, there are some cases where there's a handful of large players and several small disruptors. This means that the irreparable harm in case of over and under enforcement can be potentially greater and more asymmetric. And so as a consequence, the structure of the market could be altered for the foreseeable future if you take an interim measure or if you fail to take an interim measure. So it's really important in those cases to really be careful about taking interim measures. On the one hand, faster dynamics may increase the chance that a plaintiff could go bankrupt or lose significant market shares before the investigation concludes. But symmetrically, an incorrect interim measure could cause a defendant to go bankrupt or lose significant market shares. Conversely, incorrect interim measures against large firms may lead to harm to a great number of consumers as the investigation proceeds. Even though the harm to each individual may be small, aggregate harm across all individuals through multiple years may be large. Two consequences follow from this. An interim measure can potentially be more beneficial as a whole in the digital world. But in terms of taking each individual interim measure, there's also a risk of greater harm resulting from incorrect decisions. And so it's really important in that case to take interim measures carefully, rigorously, and on a case-by-case basis.